Welcome back, my friends, to Just Liberty, where justice and liberty meet. I'm Alan Reinach, president of the Church State Council, here with my co-host, Bettina Krause, editor of the very excellent Liberty magazine. And together we are trying to take back liberty from the political extremes. Today, our topic returns to a common one in religious liberty circles, which is religion in the public schools. Our guest today is an old friend and colleague of many years. Richard Foltin currently serves as a fellow for religious freedom at the Freedom Forum and also as executive director of the American Association of Jewish Lawyers and Jurists. And I think one of our first repeat guests on Just Liberty. So welcome back, Richard.
Great to be back, Alan.
So, Richard, it seems like this topic has really come to the fore just in the last couple of years. I mean, I was just before we came on this recording, I was looking at the Facebook page of someone called Ryan Walters, who is superintendent of public schools for the state of Oklahoma. And he is featuring a YouTube video in which he says, prayer will be protected in Oklahoma schools. It is our constitutional right to express one's religious beliefs. We are ending atheism as a state-sponsored religion. So my question for you is, where does this attitude come from? Is it founded on misunderstandings of what the Constitution says about religious expression in public schools, or is it a fair summation of the reality?
Well, it's certainly not a fair summation of the reality. I think that it's an outgrowth of partly of grievance culture, that everybody's a victim. And now people who see themselves as, some people see themselves as observant Christians, certainly not all of those that do so, think that somehow they're being closed out of the public square. And that grows out of a myth that you referred to, the notion of myth. And the myth has been for a long time, for decades, that somehow religion is excluded from the public square. It's excluded from public schools. And so I want to make an important point, which is that the schools and our public institutions generally are supposed to need to be neutral with respect to religion. But neutrality is not hostility. And the fact that they are neutral places in which people who are religious and people who are not religious can all come together and find common ground doesn't make them hostile to religion. And more than that, the notion that people have to leave their religious selves at the schoolhouse door is also a myth. And the idea has long been that since schools were forbidden by the Supreme Court back in the 60s from composing prayers or leading official prayers at the beginning of school or having Bible teaching taking place, that this was somehow throwing God out of the schoolhouse. Well, in the first place, as many people before me have said, as long as there are math tests, there will be prayer in public schools. But more seriously, there's nothing about protecting against religion being foisted upon people who don't believe and don't want to have those views foisted on them that prevents people who are themselves religious from praying at appropriate times, either themselves and when they're in school, or for that matter, gathering together in groups and doing so in a fashion that's not disruptive and that doesn't interfere with the educational mission of the school. In addition to that, teaching about subjects that touch upon religion, in which, to talk about the history of the United States, of the world generally, without talking about the role of religion, would produce a lot of very illiterate people. Maybe we're doing that anyway. But the point is, there's this myth that we need to push back against, that the schools are hostile toward religion and that it has to be claimed back in the name of religion. Quite the opposite. What we need to claim back is the idea that people of all faiths ought to be able to come together in the public schools and learn together and interact with each other and proceed on that basis.
So, Richard, what prompted us to invite you to do this show at this time was the announcement of, I think, a new publication, kind of a consensus document on religion in the public schools.
Mm-hmm.
And I've certainly seen such documents in years past, from going back to the 90s when I first started in this work. Tell us, what is this document, and what sort of consensus groups were involved with it, and then maybe we can look at how this consensus may have changed over time, if at all.
Sure. So this is Religion in the Public Schools, which has just been issued under the leadership of Charles Haynes, who is my colleague and a friend, and a friend of all of us, I think, and senior fellow for religious liberty at the Freedom Forum. It was originally a product of other organizations, uh, with Charles at the helm back when the document was originally created, and now has come together under the auspices of the Committee on Religious Liberty, which operates within the Freedom Forum, and is a meeting place, bring my common ground, a common ground for people of many different faiths and of many different political perspectives. And that Committee on Religious Liberty was consulted. An earlier version, close to the final version, but an earlier version of the document was circulated for final comments. That was after it had gone through an initial vetting team of which I was a part, but then it also included attorneys from the Christian Legal Society, the Baptist Joint Committee, uh, and Ozma Udin, who is a Muslim religious liberty scholar. So it was that was immediately a diverse group, religiously and politically, and we agreed on going really with a fine-tooth comb through Charles's draft that it represented a good statement of the law as it is today, not the law as some of us might want it to be, but the law as we understand it to be today. And I think what was very interesting about it is that, at least as of right now, that law has not changed markedly from what our understanding was, quite a few years back when the document was first prepared. So I won't go, through item by item, but suffice it to say, it deals with teaching about religion in schools. It deals about prayer in schools. It deals with teaching about religion, how you deal with holidays, et cetera, et cetera. And all of this carries out the principles I just talked about, which is that schools are not religion-free zones, but neither are they places where we're supposed to be teaching religion to people, to students. So I think it is a good snapshot of where the law is right now as of February 2025. It's a great document for sharing with school administrators and others who need to know in their day-to-day lives, in pretty clear English, not legalese, what the rules of the road ought to be. So having said that, I think, and there's a lot of these, I think, Bettina, you mentioned already, there's a lot going on in this area. The statement of Religion Public Schools that has been issued by the Freedom Forum with partners just now is a good statement of what the law is in February 2025, and is quite similar to what we would have said in 1995, say, about what the state of the law is.
Well, what's interesting to me listening to that, Richard, is what 3 years ago the Supreme Court ruled in the case of a high school football coach, Coach Kennedy, and there was a vigorous dispute about the facts in that case and exactly who did what and said what to whom and where did he pray and how coercive was it. But the Supreme Court analyzed a specific set of facts and issued a ruling in the coach's favor. And in some circles, there's a fairly widespread feeling that has changed a lot and really opened up the opportunities for more religious expression and religious activity in ways that are more coercive, more, teachers and people of leaders within government or within schools being able to use their official positions to promote religion, and to lead out in religion. And that's been one thing. Historically we've had these events, see you at the poll events in public schools where Christian students can gather prior to the opening bell, and they can have a student-led experience of prayer or reading the Bible, and teachers can be there, to kind of supervise or provide, basic, school oversight to make sure it's a safe environment. But the teachers aren't allowed to participate in leading out. It's a truly student voluntary type of activity. Um, was there much discussion about whether the Kennedy case really did change things, or how did that figure in?
So it's a great question. Let me say this about that. The I think it's fair to say that the court in Bremerton against school district against Kennedy, it's a football case. So let me say they hit the ball. And how did they do that? They did that because of what you were just talking about vis-a-vis the facts. They characterized the facts in a way that the dissent said was completely misleading and leaving out key facts, such as the way in which what was happening might be construed as coercion. They went out of their way, the majority did, to say we're dealing with a private activity that's non-coercive, that's not taking place during school time, all of which is very arguable, whether that is the case. And in so doing, they were able to seem as if they were operating within the kind of net framework that had previously existed in deciding when a school official has gone too far and is violating separation of church and state. But even though they did that, though, it's not the mischaracterization of the facts that opens the door wide open. It's the fact that the court has pretty much done away with the tripartite Lemon against Kurtzman test. Seems even to have done away with Justice O'Connor's endorsement test. It's not clear that even survives. And instead is relying on some kind of test about tradition and history that is almost impossible to parse or to apply to predict what the result is going to be.
True.
And
Richard,
so,
maybe for our non-lawyer listeners, just give a thumbnail about what that means in practice. The
okay.
demise.
So, I mean, it used to be that there was this, and this is over lawyering. So, but just to say that there was the so-called tripartite Lemon test, which said, uh, I'm not even going to try and go through all three parts of it. I'm just going to say that it was a structure that allowed you to decide whether what the court was doing either amounted to or looked like or was in fact an endorsement of religion that was inappropriate for a state body to be engaged in. And that test, I have to say, had been pronounced dead already decades ago. Justice Scalia, the late Justice Scalia, once wrote an opinion in which he said that that this test keeps coming back like a zombie from the graveyard or some other macabre, and as he was wont to do, very picturesque description. But the point is, this was a test that was under assault from the conservative side for many years, and now they finally did it. They finally stuck this to stick through the heart and put it back in the grave, and I'm done with that metaphor. But in its place, I mean, you could have had a simpler test, like Justice O'Connor's test. This is something that looks like endorsement, and if so, then it's a problem. And if not, then it's not. I mean, there's
Well,
also issues.
when you say endorsement, in other words, it's inappropriate for the government to be endorsing religion generally or a specific religion. And so I think it is worth explaining that what the Lemon test required was that government act for non-religious purposes primarily, and that the effect of their actions and laws are primarily secular and not religious, and that there not be undue entanglement between church and state, which of course respects the autonomy of religious institutions. Um, so
That's a great,
they all seemed like
great,
very sensible
yeah.
principles that are consistent with separating church and state, protecting the freedom of religious institutions, protecting secular, institutions like our public schools from being taken over by specific sectarian religious interests. They seem very sensible. I have yet, in speaking with conservative lawyers who are rejoicing at its, burial, um, I have yet to really understand exactly what they're rejoicing over. That has never been clear to me.
Yeah. Well, it's also, I don't think the lemon test, as I recall, does not specifically talk about coercion, but that's also a key element, perhaps an additional element of determining whether or not there's a violation of the prohibition on the government establishment of religion taking place. And it may be, since the majority goes to the trouble of saying that there was no coercion taking place, that they continue to regard that as something that they would like to avoid. And if there were quote unquote real coercion that even they could agree is taking place, that they would say was a violation of the Constitution. Maybe that's still the case. But the point is that advocates who want to see the tearing down of the wall of separation of church and state are in fact were in fact rejoicing in Bremerton because they did see it as a way of taking down what they have seen as an interference with what they want to see happening, which is to make government a spokesman, as it were, for religious ideas, which is, of course, totally inappropriate and inconsistent with the notion of a pluralistic, diverse American society.
And then, so really, that explains why, to a large extent, we are seeing so much legislative activity at the state level on issues such as allowing the hiring of religious chaplains in public schools or programs which provide optional curriculum for Bible teaching, such as in Texas. And then Oklahoma, which we've mentioned briefly before, which really is testing, pushing that boundary as to what is an appropriate way to teach about religion in public schools without crossing that line into advocacy for a particular religion. So, is it fair to say then that all this activity that we're observing is really an invitation to the Supreme Court to define more clearly what limits
Yes,
are?
that's exactly right. I mean, if you look at all those cases, I think in virtually every case, if you were looking back to the doctrine that was established, back when, these are practices that had just been thrown out of court. That you would not be able to require the Ten Commandments to be put up at classroom. You would not be able to have the Bible being taught as as a religious text in the schools. You wouldn't be able to have religious chaplains uh, serving really in a religious capacity in public schools. You wouldn't be able to have, well, the case, it's pending now about charter schools. Charter schools are public schools. You would not be able to have a charter school that was an avowedly religious institution uh, receive public funds to operate as a public school. We're not talking about funding of private schools, which is another set of cases. Uh, so, so all of these are initiatives that not that many years ago would have just been thrown out of court or would have lost in court. But now it's the hope of the people bringing these cases or engaging in these activities to have the Supreme Court ultimately take these cases and change the landscape and do more than was done in Bremerton against Kennedy, where again, the court, even as it threw out that lemon test we were discussing, continued to give at least lip service to some of these basic ideas of what's allowed and what's not allowed.
Well, thinking about the Bible issue first, um, and thinking about the Supreme Court claiming to rely on history and tradition, you know, I see a couple of options. First off, it's important to remember that it's always been permissible to teach about the Bible, right? And I think it's important to do that. I don't think that you can be literate without understanding the Bible because its significance in our civilization is just so large. But I mean, I've said before on various shows, when my kids were in a non-denominational Christian school, all they could do with Bible instruction was to read it because there were so many differing beliefs among the families in that school that as soon as you started to try to explain, what it meant, you were going to run into conflict, which is a little microcosm of what happens in, or potentially would happen in public schools. Um, But looking at that history, you've got, since at least say the early 60s, a history of this neutrality principle. And before that, for, what, 100 years, you had what was essentially a Protestant establishment in the public schools that is the reason why we have such a large Catholic parochial school system in the country, because they weren't comfortable with the King James Bible in the public schools, and just how much Protestant influence there was. So, and of course, I've heard from a number of colleagues like yourself in our generation who were in school before the Supreme Court decisions in the 60s, and what it was like to be a Jewish kid when there's Christian prayers and Bible readings, and sometimes, being allowed to sit out in the hall, and be excused from those things. But then, you're singled out. And, that's not a fun place for a kid to be.
Yeah, no, I will recall having assembly when I was in elementary school where they would bring out this huge Bible. It was very, I couldn't even understand how they could carry it. It was so big. And they would read, some weeks they read from the Old Testament. That was nice. But in the other weeks they would read from the New Testament, and I certainly felt excluded. Let me say, I think also it's important to note for those that want to bring religion back into the public schools that, of course, there's no such thing as generic religion. You're always dealing with specific teaching. I think, Ellen, you've mentioned this in talking about how the schools were essentially Protestant schools for a long, long time, and how that left out other Christians. And the in terms of, let's think about the Ten Commandments for a moment. We're being told the Ten Commandments has to be put up. So which version of the Ten Commandments are we going to use? I mean, even in terms of translations into English, there are differences, which are theological differences for the text. I mean, where do the Ten Commandments? But when you look at the text in the Torah, where do the Ten Commandments start? Where do you divide up the language in order to form the Ten Commandments? There are different views as to which commandments are which, and where, which portions are taken from it. Not to mention the translation of the Ten Commandments from Hebrew, from the original Hebrew, differs in interpreting certain words. So you're always making a theological choice, just in which version of the Ten Commandments you're going to choose. I think the only solution is for them to only teach from the original Hebrew, and then we know what the Ten Commandments actually said. But I don't think that would.
The one translation issue that comes to my mind is the old debate about whether it's "thou shalt not kill" or "thou
Yes,
shalt not murder,"
Murder.
which is
absolutely.
a pretty significant difference. But we won't try to solve that here.
No, and let's just switch gears because we are coming toward the end of our interview. I want to raise another related question that the Supreme Court will actually hear this term, and that is the issue of religiously based opt outs
Mhm.
to curriculum. I mean,
Yeah.
Mahmood versus Taylor is going to be heard by the court this term, and really the religiously conservative parents in this case are asking for their elementary age school children to be opted out, to have the right to opt those children out from curriculum that's dealing with LGBTQ issues. What are the factors, Richard, that the Supreme Court is going to weigh in this case?
Well, they're gonna, I think they're gonna weigh the nature of the interest in the school in educating every single student versus leaving out some students of seeking an exemption. I think they're going to weigh the hardship for the school in trying to find the right kind of exemption that works. It strikes me, looking at the law that's being applied here. If you Let's go back to that publication on religion in public schools, which talks about looking favorably towards people that want an exemption, as long as they're not trying to tell the school what to teach to other students. I mean, that seems to be pretty clear. You don't get to tell the school, don't teach the subject at all, because it's something that I find religiously objectionable. But there's clearly a sense that the schools ought to look favorably, even if the parents don't win every single time, on requests for exemption, and not impose on the religious conscience of those parents and therefore of their children. Uh, it strikes me, and I don't have in my mind a perfect disposition for this case yet, or how the court ought to come out, but it strikes me that the practice of the state is very crabbed in terms of when they're going to allow an exemption. I mean, I think that the language was something to the effect of that as long in the court below, I think, as long as uh, they're not forcing you to act in the fashion that's being described, you're having to listen to something that's religiously objectionable is not a violation of your free exercise interests, more or less I think they said. I think that's just too simple, and somewhat troubling. And it's, again, it's not to say that there shouldn't be sometimes when the exemption just can't be provided, but I don't like their approach. I don't like the fact that they seem to be so categorical about when a parent is going to be allowed the exemption and when the parent is not going to be allowed that exemption.
Well, there's a parallel in the employment setting because there are a number of cases where conservative folks have objected to the kind of motivational types of training that companies will conduct that conservatives have complained, well, it's new age, it's spiritualistic, it's really incompatible with my beliefs, and they want to opt out. um, and I think there's some positive case law in that, in protecting their right not to have to participate in those kinds of seminars and activities that are incompatible with their own beliefs. It's the exception to that, of course, are state mandates like we have in California, where many of us have to take, uh, you know, non-discrimination and harassment training periodically. I don't know. Now, I did actually do a case there where the accommodation that was needed was, in order to get through the program, you had to affirm something that you did not believe in. You couldn't just listen to it and click the right answer and give them back the answer that they wanted. You had to affirm that this was true and correct.
I think
And that was a step too far.
I think though, Alan, I mean, there is a difference between those two cases because the issue of minors makes the issue much more emotive
Sure.
in a school setting. And I'm guessing that's probably going to be one of the factors that the court will have to take into consideration as well. These are elementary school children without the capacity to, without a lot of judgment and the ability to discern between different points of view.
Yeah, I know. It's a tough case. I think, if it wasn't clear already, I'm not even sure myself at this point how I think this case ought to come out. But I do think, simply saying that as long as, and there's that language, uh, that that uh, that being required to participate in the instruction against religious beliefs isn't a problem as long as they're not being forced to change their religious beliefs or conduct, which would be a lot like, what you're talking about is somebody being forced to affirm something. Uh, uh, so here they're not being asked to affirm. The children are not being, the students are not being asked to affirm something. But still, it seems
Well, okay,
problematic.
but my understanding, limited as it is that the practice has been rather coercive. That
Yeah.
if a student objects and says something like, "Well, you're either born as a boy or a girl," the teacher's taught to push back
Right.
and tell the kid that they're wrong and that's discriminatory and what
Mhm.
have you. So it really is an attempt to change belief
Well,
and
it's
coercive.
inherently coercive, Alan, because you have an adult telling a 4-year-old what is and isn't. I
Yep.
mean, that is an inherently coercive situation, I would imagine.
I would imagine, yes. Well, on that note, I think we need to wrap this up. This has been a wonderful conversation with our good friend and colleague Richard Foltin. religion in the public schools has been and will always be one of the prime flashpoints for conflict over religious freedom.
Absolutely. We'll be able to have this conversation again, next year for sure.
Yeah, we'll definitely need an update by then for sure. And for anyone who is interested in looking at the Freedom Forum's excellent guidelines regarding religion in public schools, we will have a link to those guidelines in the show notes. And please do check them out. They are a wonderful resource and very accessible even to those who do not have a great deal of learning in the law. So thank you again, Richard, for being with us today.
Thank you for having me. It's a pleasure always to be with both of you.
So it seems, Alan, that this area of law, of church-state law, is really going to be percolating over the next few years. It's going to be an area that we're going to have to keep an eye on. I don't have a crystal ball, but Alan, I suspect that we're going to see a changing landscape when it comes to how much religion is tolerated or endorsed within public school settings. What about you?
So I go back to a metaphor that I used beginning with the Smith case back in 1990. And I think it's even more true today. And it's taken from the Roadrunner cartoon. And I have yet to meet somebody who didn't have an image of the Roadrunner being chased by Wile E. Coyote. Roadrunner stops at the edge of the cliff, and the coyote goes sailing on up there with his little feet spinning. And that pregnant pause comes when he's hanging over thin air. The foundations are gone before he falls into the abyss. And it has seemed to me for many years that when it comes to our constitutional protections for church-state separation in particular, but also free exercise after Smith, that we are precisely where Wile E. Coyote was, hanging out over the edge. The constitutional foundations are gone. It doesn't yet appear that way in terms of day-to-day life and practice. But saying that the principle now is history and tradition, well, that's no foundation really at all, right? It's whatever we say goes.
Yep.
So, yeah, what changes will come and how quickly? Um, I, I don't have a crystal ball. I tell my clients all the time, but I do think we're in uncharted waters, and there is turbulence ahead.
Well, Alan, that was an image I did not expect, and it's an image I will not forget. Thank you for that. And thank you for joining us. This has been another episode of Just Liberty. And remember, the price of liberty is eternal vigilance.